Well, I can get started with the openings. Thank you guys for coming online. Hopefully you can hear us and in person. My name is Lauren Nishimura and I'm a postdoc at the law school here. I would like to begin, before we begin, to acknowledge that we are on the lands and waters of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present. This always was and always will be Aboriginal land, and sovereignty has never been ceded. As we hear more today about the advocacy of Pacific youth from Autumn and their work for climate justice, I would also like to acknowledge the ongoing efforts of Indigenous people and colleagues for recognition and justice. So our speaker today is Autumn Bordner. She is a PhD candidate at the School of Geography, Earth, and Atmospheric Sciences, where she studies climate justice in the colonial context. She's also the founder of the Allies for Micronesia Project, a nonprofit focused on unique justice challenges in the US-affiliated Pacific Islands. Autumn is a lawyer with the Blue Ocean Law, a Guam-based international human rights law firm. And it's in this capacity, she works on a range of environmental justice issues in Oceania, including representing the Republic of Vanuatu in the pursuit of an advisory opinion from the International Court of Justice, which we'll be speaking about today, on the obligations of states in respect to climate change. Autumn holds a JD from Stanford Law School, an MS from Stanford, and a BA from Columbia University. So we're going to hear from her today talking about climate change and international law, the promise of an advisory opinion from the International Court of Justice. Autumn's going to speak for about 40 minutes, and then we're going to turn it over to Q&A. So with that, I'm going to hand over to Autumn and just make sure everybody can hear online.
Great. Yes. Yeah, and if anyone can't hear, I guess just maybe leave a comment in the chat, but hopefully everything's working. So thank you, Lauren, for the introduction and for Melbourne Climate Futures for organizing this. So like Lauren said, I'll be talking a little bit about the initiative to seek an advisory opinion on climate change from the International Court of Justice. Basically, I thought what I would do is walk through sort of the impetus behind the campaign, why seek an advisory opinion on this topic, what do we hope to achieve through this initiative, then briefly go through sort of the history of the campaign, bringing us to where we are today, and then sort of dive into the sort of substantive aspects of the legal question. So talking about the structure of the question, the content of the question, and sort of the strategic considerations that underpin that formulation. And then I'll just close by briefly touching on sort of the next steps in this initiative. So yes, just to begin, why seek an ICJ advisory opinion on climate change? And so just from sort of like a high level perspective, I mean, we all understand that the climate crisis is sort of an existential threat, and that the impacts of climate change disproportionately affect those least responsible, who are also vulnerable as a result of sort of historic injustices, exploitation, colonization by the same sort of states that are primarily responsible for the climate crisis. And we've also seen that to date, while useful in some ways, sort of the UNFCCC framework and climate negotiations have failed to produce the kind of climate action that's necessary to avert catastrophes. On the other hand, it's clear that other areas of international law clearly have something to say about climate change. It's clear, for instance, that climate change is impinging on human rights, that certain principles of customary international law with respect to environmental harm have a role to play, but there hasn't been a sort of authoritative statement of what specifically those principles of international law require, and what are the legal consequences for states who breach their obligations. And so this is really what an ICJ advisory opinion can do. It can clarify what those legal principles say in the context of climate change, and most importantly, what are the consequences for states that breach their obligations. And in that way, an ICJ-AO could really sort of catalyze climate action by making it clear what states are required to do, and yes, by making clear what the consequences are. So just to take a step back, sort of, I wasn't sure sort of the orientation of everyone in the audience. So just to provide a little bit of explanation as to why an ICJ-AO can achieve these kind of results, I first will just give a little introduction about what the International Court of Justice is and what its role is and the power that it has. So the ICJ is known as the world's court. It's the primary judicial organ of the United Nations, and it's also the only international law tribunal of what we could call general jurisdiction, which basically means it can hear any question of international law. And this is quite different than other international law tribunals. For example, ITLOS, the International Tribunal for the Law of the Sea, can hear questions specifically with respect to UNCLOS, the United Nations Convention on the Law of the Sea. There are regional courts that are competent to hear human rights issues, for instance, arising from regional treaties. But there's really no other tribunal that's competent to hear any question of international law. And of course, climate change touches on so many sort of aspects of international law that really this is the appropriate tribunal to consider this question. Within that sort of competency, the ICJ is capable of hearing two types of cases. There are contentious cases, which basically are similar to what you normally think of in terms of the function of a court. That's one state would bring a claim against another state, sort of alleging a legal wrong, and the court would deliberate and deliver an opinion that is legally binding on those two states, and those two states would be expected to bring their actions into compliance. Then we have advisory proceedings, which I can just go to the next slide, which basically are what they sound like. It's the ICJ giving an opinion that explains or clarifies what the law means in a particular context. And these are not cases that are contentious as such, so it's not brought by any one state. Instead, advisory opinions can be requested only by a UN organ or specialized agency. So the UN General Assembly and the Security Council are capable of referring a question, sort of any legal question that arises under international law, whereas specialized agencies are only capable of bringing claims within their sort of specific area of competency. So for instance, in 1993, the World Health Organization attempted to bring a claim about the legality of the use of nuclear weapons. And the court ultimately found that sort of the World Health Organization didn't have competency to ask that question because it wasn't specifically related to health. If that gives you a sense of sort of how narrow this understanding could potentially be. But then later, the next year, the UN General Assembly referred the question of nuclear weapons, and that did go forward. So yes, as I mentioned, once the question is referred appropriately and the court satisfies itself that it has jurisdiction, basically an advisory opinion, like any court, it's not creating new law, but it's rather interpreting what existing, well-established legal principles mean in a certain context, and also setting forth the legal consequences for breaches of those principles. Advisory opinions are not legally binding as such, but they are interpreting legal principles that are themselves legally binding. And because the ICJ is sort of the highest authority in terms of questions of international law, these opinions are, in fact, very influential in terms of understanding what these legally binding principles mean. So in that sense, they do carry a lot of authority and have great influence in terms of sort of state practice and state behavior. So just coming back to thinking about what the benefits of an ICJ advisory opinion are, as I mentioned already, there's this benefit of clarifying these legal principles. I think one of the big sort of barriers to more aggressive climate action is it's not clear that states have legal obligations beyond the obligation to negotiate in good faith under the UNFCCC. At least there's an argument because there's ambiguity there. There hasn't been a clarification of these legal principles. So by clearly stating, states have human rights obligations, states have obligations under the due diligence principle, it really reduces that level of ambiguity and the possibility for states to argue that they aren't legally required to take action. And that helps overcome the limitations of the UNFCCC framework in two ways. Basically, one is that this clarifies that state obligations exist outside of that framework. And second, those obligations can also sort of interpret or inform interpretation of what the UNFCCC itself requires. And in this sense, as I sort of touched on, this can also catalyze climate negotiations by reducing that ambiguity. Also, ICJ advisory opinions are very influential in domestic and regional courts as well, and are kind of routinely cited. So in that sense, in clarifying these obligations, an ICJ-AO could also assist with domestic and regional climate litigation, which is really picking up and is proving to be a really promising tool. And I think this could also help catalyze that. And then finally, there's a lot of symbolic power here too. So there's potential to sort of galvanize civil society action as well. So that's sort of overview of why we are seeking this type of advisory opinion. So now I'll just briefly sort of go through what has been done to achieve this until now, and then we'll get into the legal question. So I think it's really important to acknowledge the origins of this campaign, which was really a youth-led initiative. The entire idea of seeking an advisory opinion on climate change was dreamed up by the Pacific Island Students Fighting Climate Change, which is a student group at the University of the South Pacific Law School. So it's a group of law students who came up with this idea. And essentially they went around pitching it to different Pacific nations until finally Vanuatu sort of listened and agreed and decided to take up the initiative. So again, just, that dream of the youth, I think it's important to acknowledge that beginning. And from the beginning till now, the youth have really played a leadership role in carrying this initiative forward, both the Pacific Island Students Fighting Climate Change and also the World Youth for Climate Justice, which is a broader global coalition of youth who are calling for this action. So after Vanuatu sort of agreed to take up this initiative, they retained my law firm, Blue Ocean Law, as counsel. And in fact, Vanuatu was being courted by a lot of kind of well-known, large, wealthy law firms, but it was important for Vanuatu's government that this initiative be Pacific-led, and they had worked with us previously. We're a Guam-based law firm focused specifically on Pacific environmental justice issues, and so it was important for them to have a Pacific law firm sort of representing them in this campaign. And so instead of all of those kind of big fancy law firms, they went with us. And so after that, basically in 2019 and 2020, we carried out this really extensive and rigorous feasibility study, which was looking at the ICJ-AO initiative, as well as a variety of other climate justice possibilities, including an ITLOS advisory opinion, private litigation, and a few other things. And after completing that, Vanuatu agreed that, this seems feasible, let's carry it forward. So they launched formally and publicly this intent to seek an advisory opinion in 2021. And beginning at that time, we worked on formulating the legal question. And really the emphasis here was making sure it was a strong question that emphasized climate justice and the needs of the most vulnerable, including in particular small island developing states, so Vanuatu's needs in particular. And then we also developed a diplomatic strategy. As I mentioned, the UN General Assembly and the Security Council are the only bodies that can refer any legal questions. So we thought this should be the best way to go. So there's no question of competency, and so the question could be sufficiently broad. And also, a resolution from the UN General Assembly has symbolic power too, because it's saying, this is a question that the entire world, that all states think is important and deserves to be answered. And then in terms of implementing that strategy, we thought, in contrary to past initiatives, for example, in 2013, Palau attempted to seek an advisory opinion on climate change from the International Court of Justice, and that was sort of squashed by the bullying tactics of the United States. So the strategy here was to build a strong sort of groundswell of support from the vast majority of states who are climate vulnerable and who haven't contributed to this crisis, so that there was no need to sort of rely on the support of these large and powerful countries. So we sort of had this concentric circle approach of reaching out to the Pacific, Caribbean states, our close allies in African Union, et cetera, and sort of not listening to these large and powerful states. Then essentially a core group of 18 states was convened to sort of finalize the text of the question and to champion it through the United Nations. And a lot of momentum was building up, which eventually led to, on March 30th, 2023, the UN General Assembly adopted the resolution to seek an EAO on climate change by consensus. And this is actually a quite historic event because the General Assembly has never before adopted by consensus a resolution to seek an advisory opinion. Typically, basically, you need a simple majority of votes, and questions have in the past been sort of close or not close, but in any case, there was enough contention that a vote was required. Here, rather than being put to a vote, basically, the states are not unanimously agreed to adopt this. So it really sort of signals, again, the importance of this question that really needs to be answered, that the law needs to be clarified with respect to climate change. And I would also say this is historic, and we'll get into this a little bit more shortly, because despite the sort of pushback of states who have interest in sort of a weak question or a question that doesn't necessarily have these climate justice components, the core of the question, I mean, of course, we had to make some modifications to the question as originally formulated, but really the climate justice heart of the question, its core purpose and function was preserved through all of this. So on that note, we can sort of dive into the substance of the legal question. And yes, I'm using turtles as a motif here. Yes. Have to show that off. So thinking about the legal question, basically the request has two parts. There's a preamble, a series of paragraphs that sort of provide context to the question itself. And then there's the operative part, which includes a chapeau paragraph, which basically sets forth the sources of law that the court is expected to look to in answering the question, as well as then the legal question itself. So I'll just briefly go through some relevant aspects of the preamble, but then spend most of the time on the operative part of the question. So some key sort of points to raise about the preamble. Basically, it sets forth the competency of the UN General Assembly to ask this question, referring to past resolutions and things like that. It identifies relevant sources of law, which I'll get into a little bit more when we go through the chapeau paragraph. It also lays out the urgency of the climate crisis and its equity dimensions, as well as explaining sort of the gaps between UNFCCC goals and implementation. It gestures towards effective remedies, which I'll also talk about a little bit more later. And then one thing to spend a little bit more time on is that the preamble sets forth the scientific and political consensus on climate change by essentially referring to statements of the IPCC summary for policymakers, saying, climate change is caused by human emissions. It's already having negative impacts that are impacting those least responsible and most vulnerable disproportionately, and that we're rapidly approaching tipping points after which it will be much more difficult to avert catastrophe. And the importance of this sort of source is that not only does the IPCC summary for policymakers indicate, this rigorous review by scientists from throughout the world, but it's also been vetted by essentially all of the states who are party to the IPCC, which is virtually all states. So it's really signaling, these facts aren't up for debate. This isn't a scientific trial. We don't need to get into those details. The role that we're asking you to fill, court, is to really your core competency, which is applying the law to this specific sort of well-settled factual scenario. So that's sort of a little bit about the preamble. Going into the operative part, first we have the chapeau paragraph, which references these sort of essential sources of international law that the court is expected to look to at a minimum. And I'll just highlight a few of them briefly. So we have the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the Universal Declaration of Human Rights. So clearly this is indicating, human rights is a part of this. We're expecting you to interpret the human rights law in the context of climate change. All of these documents also specifically recognize the right to self-determination, which is really important aspect of this question. So this is sort of, gesturing at human rights clearly. Then we do have the climate treaties here, which of course are essential to the question. Importantly, sort of their framing here in the middle is really signaling, there's an expectation that, yes, these other areas of law are considered in the context of the UNFCCC and the Paris Agreement, but that's not sufficient. Like, they should be considered independently and operating of their own force, not just as sort of an interpretive tool to help with understanding the Paris Agreement and the UNFCCC. Then we have the United Nations Convention on the Law of the Sea, which codifies some important principles like the duty to prevent pollution of the marine environment and to protect and preserve the marine environment. Then we have some customary principles of international law, which basically are principles that are legally binding on all states, regardless of whether they ratified any particular treaty. So some important ones here, the duty of due diligence, and this is really getting at the question of sort of what's this, well, there are two things about the duty of due diligence. One is that it's an important sort of component of interpreting the substantive requirements of other laws. It's like, what is the standard that states have to apply with respect to implementing their other obligations? And second, it's this sort of standard of care to prevent harm. So what care do states have to take with respect to, for example, their greenhouse gas emissions to prevent harm? Then we also have the principle of prevention of significant harm to the environment and the duty to protect and preserve the marine environment, which obviously both have implications with respect to climate change and the harm that climate change causes in both the terrestrial and marine environment. So then sort of getting into the legal question itself, I can just sort of read this out and then we'll break it down into its various components. But basically the question is asking, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And then, what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment? So the first thing to sort of emphasize here is that this is one question, and in order to sufficiently answer it, the court has to do three things. And that's basically to state what the obligations of states are, to clarify the substantive content of those obligations, and also to explain the legal consequences for states who have breached their obligations. So it's not sufficient, it's not a satisfactory answer. This question is making clear for the court to merely state what the obligations are or what they entail. The court has to go further and also explain what are the consequences of a violation. And that second component is really important from a climate justice perspective, because essentially what it's getting at is what remedy are harmed states and harmed peoples owed. So sort of absent that second prong of the question, the purpose of this initiative, it really sort of loses its teeth if it's not spelled out, you've caused harm and you have to provide this sort of remedy. And I'll get into that a little bit later as well. Then when we're talking about the conduct of states, that's that issue here, it's both acts and omissions. So that means active steps that states have taken to cause harm, for example, emissions of greenhouse gases, but also failures to act. So that's not only, failure to reduce greenhouse gas emissions, but also failure to take other types of climate action like furnishing adaptation, providing compensation for loss and damage, etc. And then perhaps one of the most important phrases in the question is this have caused language, which gets to the temporal scope of the conduct at stake. So this captures past, present, and future emissions, all of which are really important. Of course, past emissions which, at the time the question is originally evaluated, have caused clearly encapsulates past emissions. But past emissions are really important for this climate justice dimension of the question, because the harm that is ongoing now and all of the harm that vulnerable states and peoples have already experienced are the result of past emissions. And past emissions are primarily caused by a few wealthy and powerful states who, moreover, had knowledge of the harm that their conduct would cause, at least since the 1970s. So if there isn't a past looking component of this question, then again, sort of like the climate justice thrust of the initiative collapses. So having that past consideration is really important. On the other hand, considering present and future emissions is really important as well. And have caused captures that too, because basically this is the consideration, this is the evaluation at whatever time the question is posed. So thinking about, 10 years from now, this question captures that as well. And yes, present and future emissions are really important in terms of sort of galvanizing climate action, encouraging states to bring their conduct into compliance with their obligations. So those are sort of the basics of the question. And then building off of that, basically this question is asked not in general, but specifically with respect to harm caused by the conduct of these states, by these states' violations of their legal obligations with respect to the most vulnerable states and peoples. Again, this is sort of getting to that climate justice dimension. So there are two groups. The first is states. So this is states, including in particular small island developing states, which due to their geographic circumstances and level of development are injured or especially affected by, or are particularly vulnerable to the adverse effects of climate change. So again, this is Vanuatu's initiative. It's really furthering their specific interests, but in addition to the specifically referenced small island developing states, geographic circumstances and level of development is basically getting at the global south, those who have contributed least and are affected most, and also have this history of sort of, as I was mentioning before, like exploitation and colonization at the hands of the same states who are primarily responsible for the climate crisis. This language, basically injured or especially affected, is referring to states that have already experienced severe harm as a result of climate change. For example, Vanuatu, who even a few weeks ago was battered by a Cyclone 5 cyclone, which is the earliest ever recorded in the South Pacific in an annual sort of cycle. And then particularly vulnerable gets at those states, like a much broader range of states that maybe haven't incurred the same level of injury, but are especially vulnerable to it. And this adverse effects of climate change language is from the UNFCCC, and it basically is very broadly defined. So it's environmental harm, but it's also cultural harm, socioeconomic harm, health, it's a very all-encompassing definition. And then just briefly, so when we're talking about legal consequences of state conduct that has violated legal obligations, basically what we're thinking about is this framework for internationally wrongful acts, which is set out in the International Law Commission's draft articles on state responsibility. And so essentially what this says is that a state that is found to be in breach of an obligation that causes harm to another state must cease the wrongful conduct and prevent repetition of that conduct, and must also provide reparation to the injured state, whether that's compensation, restitution, or some other form of reparation. And this is sort of a general framework, like the particulars may vary slightly depending on the substantive obligation that is violated, but the core is this: cessation of the violation, non-repetition, and reparation. And the preamble of the request for the advisory opinion basically gestures at areas that the court is expected to consider in terms of thinking about what legal consequences are and what potential remedies may be. So that's reparation for consequences of extreme and slow onset events, provision of climate finance, capacity development, and transfer of technology for adaptation and loss and damage. This commitment of developed countries to mobilize 100 billion per year by 2020, which was not completed. And then also, particularly the concept of due diligence would require this adoption of domestic enforcement measures to bring greenhouse gas emissions within their states into compliance. Then the other component is the harm that is done to peoples and individuals. So peoples and individuals of present and future generations affected by the adverse effects of climate change. And this really gets into the human rights component of the question. So thinking of individuals of present and future generations, that's individual human rights and the obligations of states to uphold those rights, including for groups like women and children, however these vulnerable groups, Indigenous people, may be defined. And this really honors the thrust of the youth initiative, which is really concerned about these human rights perspectives and concerned about sort of the future viability and ability to have a good life for young people today and future generations. So it's very important that it's in there. This also specifically references people's rights, and that's in particular getting at the people's right to self-determination. And this is really important, especially for small island states that are already sort of experiencing violations of the right to self-determination as they lose territory and as they sort of their natural resources are compromised and permanent sovereignty over natural resources, which is an important component of the right to self-determination, is compromised. And also, with respect to concerns about deterritorialization and loss of sovereignty and self-governance that comes along with that, these are all sort of unacceptable violations of the right to self-determination. And also important is, the rights of non-self-governing territories who haven't even had a chance to achieve self-determination and whose the ability to do so is being sort of compromised by climate change. So that's an overview of the question. Basically thinking about next steps. So where we are right now, as I mentioned, the ICJ has taken up the question, and as of now, written submissions are due in January 2024. Then there will be an opportunity for states to comment on the submissions of other states, and then there may be an oral hearing. Right now, there is a lot of discussion of different international organizations and state groups requesting an extension, for example, the Melanesian Spearhead Group and the Organization of African, Caribbean, and Pacific States. And I do think this is something that's really important because essentially a lot of the states who are most vulnerable and most impacted also have less experience with the ICJ proceedings, have less capacity to sort of develop submissions, to bring together the data and expert testimony, to even get the sort of specialized legal support that they need. And as I was mentioning, in Melanesia, cyclones, Cyclone Lola, which is a Category 5 cyclone, has, for example, Vanuatu is in a state of emergency right now. So that also, like, these direct consequences of climate change are also impinging on the ability of states to sort of produce submissions. So on the other hand, you also, you have countries like the United States and the UK who do this all the time, who have a lot of capacity and resources and can put together something really strong and excellent. So giving time to make sure that all of these states, and particularly the most vulnerable and whose voices must be heard the most, to produce, a strong submission, I think there's a strong justification for an extension there. For our part, what my law firm is doing right now is we're drafting submissions both for Vanuatu and the Melanesian Spearhead Group, which is sort of an organization of states, so Fiji, Vanuatu, Solomon Islands, PNG, and then also the Independence Party of New Caledonia, which I think is a really important voice to include in there, again, speaking about perspectives of non-self-governing territories. And then I'm actually leaving tomorrow to go to Vanuatu, New Caledonia, Papua New Guinea, and Solomon Islands to collect witness statements, which will be included in the submissions, which I do think is a really, really important part of the submissions, people having a chance to have their voices and their experiences heard. So that basically concludes my presentation, and happy to take any questions.
Well, thank you, Autumn, for a really clear overview of some complicated legal questions and some important legal terrain. I can't underscore how important this request is and how historical it is. And so I thank you for your work on this. And I know it's been many years, and for your continued efforts. So we're open for a question and answer now. If you have any questions, please raise your hand. And if you could introduce yourself before you ask the question, that would be great. I might have to repeat them since we have some audio issues. I think John is going to start it.
Hi, I'm John.
Hello.
I have a comment and a question. All right, the thing I've just now last thing about submissions, and if you look at since the IPCC AR4, I think they did an AR5, since they produced maps of evidence of observed climate impacts that are consistent with projections of climate change. Data correlated between those two the first time. And if you look at the geographic distribution of that map, what it is a map of countries that invest in science. So that all the evidence, and these are things like, observed changes in the distribution of species, all the really robust scientific evidence that we do for climate change comes from developed countries, because that's where the research is invested. So the scientific case also suggests there's a huge equity problem about the evidence of impacts, peer-reviewed evidence of impacts, which is interesting. Yeah. Last question, but if I was a diehard UNFCCC fan, would I be worried about this?
Yeah, that's a good question, and one that we get a lot. I guess just to maybe briefly respond to your comments. So it's a really good point. I mean, in terms of sort of Western scientific understanding, what we're trying to do, especially for the Melanesian Spearhead Group submission, is sort of provide expert testimony in the form of traditional and indigenous knowledge. So not really relying on these Western concepts of what expertise and science is, but providing, knowledge that's evidence based on knowledge that's just as valid. That is not necessarily, in from places that Western science doesn't touch as much. Yeah, exactly.
Somebody more science in the US. We're the ones that.
Yeah, so that's why. And luckily, I mean, it's interesting the ICJ is, I think its rules of evidence are very minimal compared to sort of like domestic courts. So there is more leeway there. And I do think, again, this is also an opportunity to sort of challenge that notion of what expertise and what legitimate evidence is. And then with respect to your question on the UNFCCC, we see this really as a initiative that complements the UNFCCC, because again, what we're doing here is basically clarifying existing law, which includes sort of clarification of what action states have to take with respect to the UNFCCC. This isn't meant to be something that's necessarily antagonistic. I mean, it's clarification of general principles. It's not pointing a finger at any particular state. So yeah, we see this as complementary and further as sort of catalyzing climate negotiations by clarifying these principles and reducing the ambiguities that often result in sort of sticky situations.
Sorry.
I'm just wondering, we recently saw the loss and damage negotiations that the loss and damage fund doesn't really have any binding obligations of states to provide resources that way. But I see that you listed climate finance as one of the potential legal consequences that could come as a result. So I'm just wondering whether you see climate finance, particularly in the context of loss and damage, as a primary obligation of states to provide, or a legal consequence of them breaching these obligations?
Yeah, that's a good question. I mean, oh, sure. Yeah, the question was basically thinking about climate finance and whether it's considered a primary obligation of states or a remedy for harms that have been caused. And yeah, I mean, I think in different contexts, it could be seen as sort of both, depending on the sort of substantive obligation at issue. And that's I mean, we can make arguments, in both cases. And I think it's valuable to make arguments in both sort of respects. It's something for the court to opine on as well. But I mean, at minimum, it's clearly like something that is owed to correct harm.
My name is Fred Patterson. I'm just visiting, but I work for Spread. They started up here, but I'm from the Solomons. My question also relates to the questions on the potential areas of remedy. I noticed that a lot of the bullet points you mentioned are related to some of the expected outcomes of the UNFCCC process. Are you looking outside of the UNFCCC process in terms of other remedies that you're thinking about? A lot of these points are related to some of the negotiation priorities for the season, particularly.
Yeah, that's true.
Remedies that you're thinking outside of UNFCCC?
Yeah, I mean, I think there are a lot of different remedies that can be sort of requested and thought about, and we're honestly sort of like thinking through the slate of remedies to recommend currently. Like, these are some that are very obvious and that are sort of ground in the concerns that states have been raising and the needs of states currently, but certainly you can be more imaginative as well, I would say. It's under development.
Then I guess we can take an online question.
Okay.
Here. Let's see. Sorry, we're both using the same. So online, we have a question. There is some scholarly opinion that seeking the advisory opinion is risky because if the questions are answered in a disappointing language, it might take the fight for climate justice back. Was this risk considered during your preparatory stages? And then the second question, how significant was Global South solidarity in this whole process? And at what point was this demonstrated most powerfully? Those are great questions.
Yeah, definitely. Great questions. So yeah, I mean, of course, there's always a risk of sort of an underwhelming opinion, in particular, sort of perhaps one of the most disappointing outcomes would be, a conclusion that states have obligations to negotiate in good faith under the UNFCCC and sort of stopping there. I mean, this was very much thought about in terms of the strategy of formulating the legal question, making it clear that the court has to look to these other areas of law, that it's not sort of acceptable to just limit consideration to those particular treaties. And yeah, I mean, it's true that there's always a risk, but we've thought about sort of the formulation of the question and the interpretation by the court in a lot of detail and sort of settled on this language. For instance, the language of legal consequences, that's language that the court considers all the time. It knows what it means. It knows what's expected of it. It knows that it has to spell out sort of the consequences of a breach. For example, that's sort of the Chagos advisory opinion was that request was referred in the language of legal consequences. So it's a standard formulation that we can have a great deal of certainty in. Yeah, and I think I touched on this a little bit before, but the solidarity of the Global South was actually quite essential in terms of carrying this initiative forward. Like I mentioned, it was that strong upswell of solidarity that really allowed us to stand strong against this pushback from basically the global north, who were asking, for example, for a question that was only forward-looking. That was the big sort of push from the global north. Also, like a question that just looks at obligations and doesn't consider legal consequences. That was something that was really heavily pushed by the global north as well. But the sort of strong stand of states from the Pacific, from the Caribbean, from Africa, from throughout the global south. I mean, OACPS was one of the first major endorsements that we received, and that was really helped to mobilize other states and build the momentum around the initiative. So it's definitely been a partnership, certainly in the diplomatic campaign, and also in the core group. A lot of the heavy lifting was done not only by Vanuatu, but by our partners in the core group from Latin America, from Caribbean, from Africa, and throughout the Pacific.
And then I actually had a question
Mhm.
related to that. So there's also the advisory opinion request before the ITLOS, or the UN Law of the Sea body. Was there any coordination during the lead up into this with COSIS, which is the group of island states that submitted that request, in terms of what you were including and being strategic about the timing of that ITLOS was going to potentially come first before the ICJ? And do you think that what the repercussions of that will be for the ICJ opinion? Do you think they'll just reiterate what's been said by the ITLOS tribunal, or? Yeah, I'd love to get your thoughts.
Yeah, sure. That's definitely a good question. And yes, we did coordinate with COSIS. There was a lot of back and forth in terms of considering sort of the sequencing of these questions and the substantive content of these questions. I mean, for a time, there was a hope that the ICJ question would go forward first, but it's a little bit more of a heavy lift and a slower process. So in the end, it was sort of determined, we might as well let this one just go forward. And in any case, a strong sort of outcome from the ITLOS tribunal would not be harmful.
No.
So yeah,
Maybe the opposite.
exactly. Mm-hmm.
Yeah.
Want to go ahead?
I think
We'll come back to it.
So thanks for the answer, Joe. Let's go, Joe. We have a couple of questions. You mentioned the importance of having local witnesses and evidence from local witnesses. So when you could say a little bit more about the process of getting evidence from local people, was it done like in terms of sort of like mediation with NGOs or more governmental? And in that sense, also, I was wondering, more of a technical, maybe legal question, but does the ICJ accept as evidence rulings from local courts and from courts in over national and international courts?
Yeah, so in terms of collecting witness statements, it's ongoing right now. I mean, this is why I'm going to Vanuatu tomorrow. So like us, the primary legal team, are collecting some of the testimonies. We're also actually the youth, the Pacific Island Students Fighting for Climate Change, also has a ground team in their communities that is sort of dispatched to collect testimonies, which I think is, in a lot of ways, a better sort of entry point, because it's folks reaching out to people in their communities who they know will have sort of valuable information to share. I mean, some NGOs have been interested in assisting as well, which we're open to in a sense, but for now we're sort of trying to stick with our trusted partners, and we've developed a protocol around sort of, the ethics of this, as well as the evidentiary requirements of the court. And yeah, we're hoping to also record these as audiovisual as well, because there's also an opportunity at the oral hearing, if there is one, which there almost certainly will be, given the sort of significance of this question. So to sort of have people, their voices heard in their own voice before the court. Yeah, I mean, the court can certainly consider the rulings of other tribunals, and certainly like other international law courts and regional courts can sort of offer persuasive authority as well. So.
Anybody else have a question? Sorry,
It does build on certainty. Alex found in terms of the witness statements, I'm just wondering how you couple that with scientific evidence to some extent, but also in that process, for example, if you go out to some of the remote islands, the first thing that comes to mind about climate change might not be saline ingress that's damaging crops. It might have to be sort of unpicked from a number of layers because of varying levels of literacy of what is or isn't actually climate attributable and attributable to climate change. So I was wondering how you factor that. There's a little tag onto that. I was wondering how you're trying to deal with both future non-linear trends, so things that maybe will get worse and therefore maybe won't be as evident in what you're seeing with the statements now, and also some of the more step changes that are sort of thresholds that are in the near future that aren't too far off. Things like ocean acidification, which have massive ramifications for marine and sea life systems that will then have knock-on implications for both people and ecosystems. So
Yeah, definitely good questions. A couple of things there. So one is that we're sort of marrying witness statements with expert reports. And as I mentioned before, some of these expert reports are scientific, like we have an expert report on attribution science or an expert report on tipping points, for instance. But then we also have, for example, expert reports on cultural loss and on sort of traditional knowledge, which kind of helps to lay the foundation for these witness statements that may be grounded less in terms of like climate science and more in terms of cultural knowledge or observations of changes. So marrying those together helps to sort of contextualize these observations for the court, which, you know, another consideration here is that this is a court of general sort of jurisdiction. It doesn't necessarily have any specific background or fluency in matters of climate science, let alone sort of the perspectives of Indigenous peoples and local peoples who are experiencing these sorts of losses. For example, you know, like loss of traditional crops through saltwater inundation, loss of connection to place like sacred sites, that sort of thing. So marrying sort of these firsthand accounts with expert reports. For instance, I mean, we have an expert report from a cultural practitioner who is grounding his expertise in his own sort of knowledge and experiences. So, but he also has this sort of like scientific training and can phrase it in a legible way for the court. So that's one of the ways that we're working on that. And I think it's sort of like a similar marriage with respect to thinking about future impacts. We're having, you know, if you're observing, for example, coral bleaching now, and people are already experiencing those impacts, we can have statements about that, statements about what people are concerned about for the future, for example, like transference of culture, whether that culture may still be viable. But then we also have the expert reports and testimonies, more like scientific, about tipping points and affected sort of step changes and exponential changes.
So interesting discussion. One comment and a question. I think this thing about the risk to climate justice is probably worth saying that consensus from the UNGO and recommending this to the ICJ. I doubt the UNCCC has ever had consensus on it. So that already is actually really impressive. I mean, if you were to put any question about climate justice to the UNCCC, you wouldn't get consensus for that. So it's probably worth noting that. I think like it's an already important issue. This kind of goes with what Lexi was saying. I'm really interested by the phrase significant harm to the climate system, in contradistinction to Article 2 of the Convention about dangerous climate change. So part of the problem with the Convention with dangerous climate change is really, you know, they specify, the specification is very unhelpful actually. And so there's all that work done on operationalising Article 2. We're going to hope that if we could define what dangerous climate change is, we could set benchmarks for emissions. And that's where the 2 degrees thing comes from. But I wonder if significant harm to the climate system is better or worse than dangerous climate. What's harm to the climate system is an interesting thing.
Yeah, it's harm to the climate system and also other parts of the environment. So it's not just limited to sort of harm to the climate system, but also the knock-on effects of, you know, harm to the marine environment, harm to sort of agriculture. Yeah, that's true. Basically, when we're talking about obligations, we're thinking about harm to the climate system and the environment. But then when we're thinking about the harm that is caused as a result of breaching those obligations, we're thinking about sort of a broader range of harms there.
I was just wondering that maybe that is a question I had too. Like there wasn't any mention of biological diversity or the Convention on biological diversity in terms of showing that harm. Was that a strategic decision or to focus on human impact?
No, we are going to be considering biological diversity as well. And in fact, the Convention for Biological Diversity is at least referenced in the preamble. But But yeah, I don't think I have it up there. I didn't sort of go through all of the law reference there, but yeah, I mean, for instance, sort of like our trip to PNG is basically focused on collecting evidence with respect to biodiversity loss, although that's also linked to sort of cultural loss, for instance. Yeah.
I have a question.
I mean, the question from the city financial, so just a comment, this was a very interesting presentation. I actually was doing a research on it. I was just wondering if you have a PDF version of your presentation and we could circulate it. But also, I had a question on, not a question, but a comment. I know that your legal mission was on the obligations of state and not of legal. But also in terms of the UNSC, the main negotiating point for the SIDS is there special circumstances. I was just wondering if this progresses, then how it can affect the main negotiating point from the SIDS in terms of their special circumstances. And also, sometimes they refer to themselves as controversial states.
Yeah. I know. I also prefer the large ocean states definition. Yeah, I think this is sort of couched in the more dominant language, and unfortunately, that's sort of I guess, the reality of a kind of oppressive international system. But yeah, I mean, certainly this is hoping to carry forward sort of the particular concerns of large ocean states. In particular, when you think about, I'm not sure if I still have my slides up, but thinking about, we have obligations and consequences, but then when we're thinking about application, the question is really asking about what do states owe for the harm that they have caused to these particularly vulnerable states and peoples, and small island developing states are specifically mentioned there. So yeah, the question is really hoping to focus on fleshing out what is owed to these particularly vulnerable, specially injured, and specially affected states and peoples.
I think we're out of time, so I want to say thank you again to Autumn for this wonderful presentation. Thank you guys all for coming, and I know we could talk about this for a lot longer, but thank you. And
oh, and I will definitely, we can circulate the PDF.